ladies and gentlemen, a very warm welcome to this second webinar of our series that delves into the ever-evolving landscape of corporate responsibility and government responsibility in the 21st century. My name is Fremuth-Wolf, and I'm working with the Swiss-based litigation fund Nivalion AG, and together with my colleagues Lucas Macedo and Simon Knupfer, and of course our esteemed partner and friend from Wöss & Partner, Herfried Wöss, we have decided to continue our ESG-focused webinar series after a very successful launch in February this year. Actually, in February, we were focusing in 2 webinars on the topic of ESG in EU-related supply chains. Also, this webinar series were recorded, and links will be provided or can be seen from our website for those who are interested in that topic. This webinar series is titled Where the Rubber Meets the Road, the Reality of ESG Claims. And we started off on 21st September, where the topic focused on Fight the Good Fight, from the trenches to policy and decision makers, ESG pressure points, where we featured Johannes Wesemann from All Rise, Andreas Hösli from Walder Wyss, and Sora Laya from Barbosa Avogados. We got insights from NGOs, how it is to launch claims, getting the insight also from counsel, and into this very interesting field. I invite you to watch the series, and I will post the link in the chat afterwards. Today, we gather under the theme, It's Not Easy Being Green, the Cost of Doing ESG Business. In an era where environmental, social, and governance considerations shape the very fabric of corporate decision-making, we are very privileged today to have 3 distinguished experts guide us through these complexities of this transformative journey. I will now introduce the 3 speakers that will go in consecutive orders. And if you have questions to the speakers, please post them in the chat, because there will be a Q&A session following the 3 presentations. Our first speaker is Isabella KAMINSKI. She is a freelance journalist specializing in the environment and climate change, who has written for a wide range of specialist and generalist publications. She has a particular interest in climate litigation and writes a newsletter on the subject called The Wave. Next, we are honored to have Amanda Neal. She's general counsel at the Head Group, which is a sports equipment manufacturer. Prior to joining Head, she was special counsel at Freshfields Bruckhaus Deringer, where she specialized in international commercial and investment arbitration, with a particular focus on ESG issues, and also sat as arbitrator and tribunal secretary. Amanda is qualified as a solicitor in Australia and England and Wales, and speaks German and English. And last but certainly not least, we are joined by Viren MASCARENHAS, partner at Milbank and a member of the firm's litigation and arbitration group. He specialized also in international arbitration, public international law, and business and human rights. He has really almost 2 decades of experience acting as counsel in domestic and international arbitration proceedings under major institutional rules, as well as ad hoc arbitrations. Viren's public international law experience includes advising governments on a range of international law issues, such as maritime and territorial boundary disputes. Well, now with much further ado, I will hand over to Isabella, who will talk about the financial implications of ESG claims on corporations and their balance sheets by reflecting on the recent report of the Grantham Research Institute on Climate Change and the Environment. Isabel, the floor is yours. We are curious to hear your insights.
Thank you very much, Alice. So as Alice has kindly introduced me, I'm a journalist who's been writing about environmental and climate law for nearly 15 years. I've covered legislative and regulatory developments in the UK, the EU, and to a lesser extent, the international level. But over the last few years, I've been focusing my work on the growing field of climate litigation. And I'm hoping I will share with you a few graphs which I can help illustrate this. as you can see from this, the number of lawsuits filed by legal groups, campaigners, and individuals to try to compel action on climate change using the law has really exploded in the last few years. There have been well over 2,000 lawsuits to date relating to climate change, and that's all around the world. So most of them are, actually, sorry, there we go. Most of them are in the US, but there's a growing number in other countries as well. The low number in 2023 just reflects that when the report was produced, because it only covers cases up to May, but we expect there's going to be a similar number this year as well. And so most of those lawsuits challenge state inaction. In 2019, a Dutch NGO called Urgenda won a landmark case in the Netherlands Supreme Court when it ordered the government to cut its greenhouse gas emissions by at least 25% by the end of 2020. And so that case inspired many copycats around the world, also challenging government carbon reduction targets and strategies, and many of those have succeeded. So, as well as lawsuits against governments, the world's most polluting companies are increasingly being targeted for their inaction on climate change and also for attempts to spread misinformation. Although the fossil fuel industry, as you can see, is mostly in the spotlight, other sectors are now increasingly targets as well. So food and agriculture, transport, plastics, and finance have all seen lawsuits, and it's only going to grow. It's also increasingly starting to affect sort of more service industries too. So it's probably unsurprising that climate change is being litigated using administrative law, but it's interesting that claimants are also now using human rights arguments, and it's cropping up in commercial, planning, tort, contract, trust law, you name it, it's there. We also know that regulators across the world, in the UK, the EU, US, are clamping down on perceived greenwashing. So only yesterday, the UK's Competition and Markets Authority said it was investigating a boiler manufacturer for marketing its boilers as hydrogen ready, which it said was a very dubious claim. So this has really become a legal movement as well as an academic field, and one where campaigners are working together across the world in a really unprecedented way. So the Intergovernmental Panel on Climate Change said it was one of the most important new avenues through which climate policy is being shaped. But I still think this important question to ask is this kind of legal action really working on the ground in the way we want it to, in terms of cutting greenhouse gas emissions? So we know it makes headlines. It advances powerful arguments and often features sympathetic claimants, as you can see in these kind of cases: young people, older people, people with particular disabilities, people from vulnerable communities. Those involved in climate litigation say that shaping the public narrative is almost as important, if not more so, as winning the case. But cases are also being won, certainly against governments. And there have been definite changes in policy and in strategy as a result, although not always as much as campaigners had hoped. When it comes to corporate lawsuits, it's more difficult to tell because not as many have succeeded. Lawyers have told me that they are advising their clients about climate litigation risk, and I'm sure my panelists will be discussing this in more detail. And they also expect it to become a recurring theme in annual reporting as companies become subject to stricter disclosure rules. So, for example, BP's latest climate-related financial disclosure report from April said legal proceedings could reduce its financial liquidity and its credit ratings. So it is on their radar. But the report that I wanted to talk to you in a bit more depth today comes from the LSE, because researchers there, they really wanted to take a more scientific approach and see how it was affecting a company's bottom line. So they looked at how the stock market reacted to news that a fresh climate lawsuit had been filed or a corporation had lost its case. And they analysed 108 climate lawsuits around the world over a period of 16 years against 98 companies listed in the US and Europe. And it's quite a sort of technical report. They really go into the statistics around this. But they found that the filing of a new case or a court decision against a company reduced its expected value by an average of 0.41%. The stock market reacted most strongly in the days after a case against a carbon major. That's a label given to the world's biggest greenhouse gas emitters, so the largest energy, utility and materials firms. Their relative value dropped by an average of 0.57% after a case was filed, and 1.5% after an unfavourable judgment. So they are admittedly modest drops, but they are statistically significant. And so the researchers concluded that climate litigation does pose a real financial risk, certainly to fossil fuel companies. They also interestingly found that share prices fell more in reaction to novel cases involving a new legal argument or filed in a new jurisdiction. So an example I wanted to give was a case brought in Germany by a Peruvian farmer and mountain guide called Saúl Loya. And he filed an unprecedented legal claim against RWE in 2015. His hometown is a village in the mountains just below a huge glacier, which is melting. And his argument is that RWE contributed a certain proportion to global carbon emissions, which is contributing to the melting of the glacier. At some point, the glacier will cause a flood that will destroy his hometown. And he wants compensation from RWE in response to this. So when the case was filed, RWE's relative share price dropped by 6%, so really significant. And then again, 2 years later, an appeals court allowed the case to proceed. It dropped by 1.3. So that case is still ongoing. Court hearing is expected sometime next year. But it's a really important one because if the court rules that RWE has to pay compensation, even what is really going to be a very small amount for such a big company, it could really open the floodgates for other claims against other big emitters. So we know that the world's fossil fuel companies are watching that very closely. And there's another important case with a more complex picture that the researchers looked at. That's brought against Shell by a Dutch NGO. And they argued that the company had an obligation to reduce its carbon emissions from its whole global operations. So when the case was filed, Shell's relative value actually rose slightly. But 2 years later, when a court ordered it to cut its global carbon emissions by 45% by the end of the decade, the share price fell by 3.8%. Shell is appealing that decision, although it is supposed to comply in the meantime. So what's really interesting is that the researchers found consistently larger effects on corporate share prices after the Shell case. So they say that's suggesting the capital markets are increasingly responding to climate litigation. And it goes back to something that lawyers had been telling me, that when a case is launched against a particular company in a particular industry, they suddenly get an influx of calls and emails from other people in that industry concerned about how it's going to affect them. So one case can have that real knock-on impact. So we know that there's an impact on share price. We know that companies are watching this field carefully. What we don't know yet is whether climate litigation is really driving substantial changes in climate action amongst the biggest polluters, which will have the real impact on cutting global emissions, but that remains to be seen. Yeah, and if anyone wants to find out more about that, then yeah, my climate litigation newsletter covers these cases in quite a lot of depth. Thank you.
Thank you so much, Isabella, for setting the scene. That was really super interesting, and I really urge everyone to have a look at these studies and read it in depth. It's really super insightful. Amanda, Viren, would you like to comment before your intervention starts immediately on the findings of the report? Is there anything you would like to add to that? Or any comments or questions that you have for Isabella in that respect?
Sure, I found that very interesting, and I do some work in the area of climate change litigation, and my experience working with companies and in-house counsel is, that they take these litigations that are being filed or could be contemplated very seriously, both because of the impact on the value of the company, which is, captured sort of in shareholder sort of market cap, but also in terms of sort of reputational, what their peers are doing and what their sector is coming under in terms of scrutiny in these litigations. What I will say is, 8 years ago, I was instructed by a US oil major that had been sued is the wrong word because it was more of a non-litigious proceeding. It was before a human rights commission in a Southeast Asian country. And the allegation was that fossil fuel emitters, fossil fuel companies and cement companies had contributed to greenhouse gas emissions that had resulted in sort of turbulent weather affecting the coastal areas of this country. And that impacted the people who lived along there. And what's interesting is that there is a decision that companies have to make, which is what legal tools do we have at our disposal to be able to defeat this claim? For example, in the US, you'll have, is this the right forum to be sued? Is it state or is it federal? Do you have standing over a federal jurisdiction over the defendant? But there are also questions of sort of attribution, to what extent, even if we are doing wrong, can we be singled out for our contribution to this greenhouse gas emissions that's resulting in the climate change negative impacts. And I think now, about 8 to 10 years later, we're seeing some of these cases result in victories, and Isabella identified some of them. The Montana decision was a very significant one here in the US. Of course, that decision was grounded in the Montana state constitution, in which there was a right to a healthy environment that the court used to make its findings that Montana regulatory authorities have to take into account climate change for all extractive projects in Montana. So there was a legal hook to help the court get there. That wasn't sort of, breaking new ground through what some will consider judicial activism. It was the law in the Constitution. But we're seeing sort of those developments in that front. Where this connects in the US is right now there is draft SEC regulations on climate change disclosure, and looking at what those who are registered in the US or foreign registrants in the US securities market, will have to say in their financial statements and periodic reports about things like climate-related risks for the registrants' business activities, their level of greenhouse gas emissions resulting from their business operations, certain climate-related financial statement metrics, and also any transition plans they have. For example, if they are moving towards green energy, the energy transition, and what their climate-related targets are. What this will result in actually is more information that's being disclosed to the SEC in these public filings with assurances, right, of third-party auditing or other standards that are being set out even in the EU, for example, on the Sustainability Reporting Directive. This data will actually become the ground for a lot of the lawsuits that are going on now. And some of these attribution issues, to what extent can a company be held accountable, where that has been hard to show in the last 10 years, will become probably easier to demonstrate because we'll have access to the company's own verified data. So that's something, these sort of regulatory developments will feed into the litigations that Isabella was discussing.
Yeah, thank you very much. Isabella, would you like to respond?
No, I think that's a really helpful intervention, and it's an interesting point about how disclosures will possibly provide a kind of evidence base for some of these cases.
I think the report also talked about the phenomenon of strategic climate litigation, that this is sort of more and more used, where you probably even from the outset you reckon that you won't win at the very beginning, but you want to set the scene for a series of cases. Is this also something that you consider will be more relevant in the future, Isabella?
I think it will continue to be, yes, absolutely. A lot of these cases are strategic, in that they are very carefully chosen in terms of their targets and their jurisdictions, partly to maximize a win, but also often to set a particular kind of legal precedent, or to move the law on a certain way to test the law so that somebody else can come in potentially and bring a subsequent case that can build on it. That's already a very well developing field, but I'm sure that will continue.
Yeah, well, I mean, usually it's more the bigger companies, or the major oil and gas and coal companies that could be targeted to these strategic claims. There's also a risk, and now I'm handing over to you, Amanda, to the in-house perspective. When you listen to all that, I think being an in-house or being a corporation, how do you manage all the risks that can be involved in doing business these days? What are the considerations and challenges faced by corporations today that have not been here a couple of years before? And actually, how do you handle all that in practice? And of course, you're free also to comment briefly on the report and give your perspective on that. Thanks.
Yeah, perhaps I just start. Thank you very much, Elisa. Perhaps I just start briefly with Isabella's presentation, which was fascinating. And I think the interesting thing from my perspective is when you're looking at risk and you're looking at disputes, we're seeing a lot in the space of climate change. But of course, ESG, sustainability, is much broader than that. And a lot of the sustainability in ESG issues we're dealing with in-house are, human rights related issues, other environmental issues, and not necessarily climate change specific. And I think it would be really interesting to hear Isabella's perspective on whether or not she sees any scope for the kind of disputes landscape we have in climate change extending to other areas of ESG and sustainability, whether or not we're looking at the beginning of, a raft of disputes in all different types of sustainability areas.
Thanks, Amanda. I will say that I have been quite sort of focused on climate litigation, so I may not be able to speak so much about what's happening in the rest of the ESG space more broadly. I know I have been looking a little bit at biodiversity litigation and the potential for that to grow as a field, but also there is overlap with climate change there, which is one of those topics that people say is sort of it's coming. It slightly depends on how you define biodiversity. I was talking about things like supply chain risks and deforestation, as well as sort of a building that's affecting a particular species. There are some bigger corporate risks there, I think, around that. But the more broad ESG space, I'm afraid, isn't something that I could speak much to.
Well, and thanks very much, Elise, for your introduction. As she mentioned, I'm going to be talking a little bit about the in-house perspective, and I think it fits in nicely with what Isabella said. She spoke a little bit about the impact of climate change litigation on share prices and so on. But I think there's another aspect to the cost of being green, so to speak, and that's the sort of internal transformation that companies are undergoing. As she mentioned, there's a raft of risks associated with sustainability, and of course, that is affecting businesses on the ground, and people like me in the in-house capacity are dealing with a lot of those issues. And I think the fascinating thing about the sustainability space is that sustainability is obviously, and the sustainability transformation is one of probably the single biggest issue facing businesses today. And it's very interesting because it doesn't affect one or two departments of a company, and it doesn't affect one or two industries, but it really is a whole of business issue. And that is because it's a whole of society issue. And so that's absolutely not surprising that all businesses and every facet of a business has to think about sustainability and ESG and what it means for the way we do business and what we have to do differently in the future. And what's even more interesting about it is that for many industries and for many businesses, it's an existential issue. It's really something that goes to the core of what we do, especially when you think about issues like climate change. And for example, in an industry like ours, we're sports equipment manufacturers, and one of our special areas is winter sports. And obviously, we're looking at a situation where, people cannot go skiing and practice winter sports because of issues like climate change. So it goes to the very core of what we do. And that's obviously a massive risk for us. And I think, the fascinating thing about sustainability risks is that they are so big, they're so complex, and they're so multifaceted. But at the same time, they're a little bit unclear, and they're constantly changing. And it's a little bit like when you sort of look out on the horizon, you see something big in the distance and you know it's coming, but you don't exactly know what it is and what impact it's going to have. So you're constantly trying to watch and adjusting your posture and adjusting your position to make sure you can respond to it in the most effective way. But I think one thing that is quite clear, and there's no real debate about that, is that it's going to be quite expensive to deal with these kinds of risks and to transform our businesses to do that. But the other thing that's also clear is that if you play your cards right, if you do it properly, it's also a massive opportunity. And that's often the case when big risks are involved. And the challenge for us as a business is to minimize the risk and to maximize the opportunities. And so that's what I really wanted to focus on today, how we approach the risk and how we identify the opportunities in the risk and try to maximize those opportunities and minimize those risks. So I think one of the things that I found really interesting as an in-house counsel is when you think about risk, you have to have a much broader perspective on risk than you would if you were a lawyer in private practice, especially if you were a lawyer in disputes field. And I was a dispute resolution lawyer for many years. And so we thought about risk very clearly as a type of a very narrow legal risk, which is totally appropriate in that context. But when you're in a company, when you're in-house, you realize that legal risk is just part of the risk profile for business and for companies. And we can't just think about the legal risk, but we have to think about the broader commercial risk. And the legal risk fits into that picture, but we often interpret it from a commercial perspective and not just purely from a legal perspective. And I think the reason for that is obviously that businesses have a profit motive. We're here to make money. And risk basically represents a potential financial loss. But it's also because in business, the commercial risks often are more obvious and more apparent, and they come before the legal risks. And we very often hear things, especially in sustainability, from our customers, our employers, from our business partners, from the market and from our stakeholders before we hear about them from lawyers or regulators or legislators. And I think I remember when I was in private practices, there's always this debate amongst lawyers, are we leaders or are we laggards? You know, are we leading the way in these conversations or are we following? And I think, you know, in sustainability, it's very much the case that society and business are ahead of the law, and the law is catching up. But we did know a lot about these risks before it became a legal issue. And the other interesting thing about it is that you can't really respond to these risks without the law. So the law is now robustly responding to these kinds of commercial risks that we're facing. But you simply couldn't do it without the law because the problems are too complicated and they're too big, as I mentioned. But the role of the law is quite an interesting one. It's to sort of take the risk and kind of define it, to clarify it for us, to say, this is what you're up against and this is what you have to do to avoid these risks. And so it's actually a very helpful role that the law plays in dealing with commercial risks relating to sustainability, because it does help to make things clearer. And in an environment where, as I mentioned, it is unclear, you do need some signposts. You know, if you follow these sort of signposts, that you're going to be protected. But in terms of the specific commercial risks that we as an organization, and I think many organizations face, I mentioned the existential risk because of, you know, we can't exist in an environment where, you know, extreme climate change is the reality. But we also face a number of commercial risks from our stakeholders, from our consumers predominantly, who are very, very astute and clever people who are largely athletes who are very conscious about ESG issues and environmental issues, and they only want to deal with companies that reflect their values. And if we can't sell our products, we obviously can't make money. We also have risks with our employees because, again, they're young people, they care about sustainability, and they don't want to work for a company that doesn't reflect our values. If we don't have the best people, we can't develop the best products and we can't sell them and make money. And we face risks from our business partners who demand, you know, appropriate level of behavior from us. And in fact, we do a lot of B2B work. So our business partners are very big retailers and very big companies who face larger legal risks than we do, who are heavily regulated. And one of the ways they deal with that risk is to pass it down to the supply chain to us. So we end up in a situation where we have to, through contract and through policies, we have to comply with a much higher legal standard actually than we otherwise would have to comply with by virtue of regulation alone. And, you know, finally, and probably, you know, one of the most significant risks we face is from the market. And that is general, you know, the risk of general reputational damage by not being seen to be a good corporate citizen, not be seen to, you know, care about these issues is a huge one. And again, very bad for the bottom line. And these kinds of commercial risks are the kinds of risks we're facing, and they all are ultimately financial risks and are risks to our ability to effectively do business. And then we move a little bit more into the side of the legal risks. And these risks, as I mentioned, they sort of arise when the lawyers and the regulators and the legislators, they pick up on a particular issue and they turn it into legislation or regulation or contract that we have to deal with. And those risks do arise mainly from contract, and in our situation, contract, and from legislation and regulation. And as I mentioned, the very big one for us, and I think for all players in any kind of a supply chain, is that even if you're not directly affected by a particular regulation, if you are interacting with anyone else who is, which we all are because we're all interconnected, you are affected by that regulation. You have to think about what that means for your business, and you will find yourself having to comply with those standards, even if the regulation doesn't affect you directly. And that's, I think, part of the very, I suppose you could say from a legal perspective, the beauty of this regulation is that you really only have to go for the big fish, and we all are, drawn into that. And that is the trickle-down effect is exactly what is intended by this regulation. And in terms of the specific legal risks that you face, those do vary. But they also change, as I mentioned, because the definition of ESG changes. And so they mean different things to different organizations. But if I can just give an example of our organization, we are facing things like issues relating to our CO2 footprint, very big issues relating to recycling and packaging and waste. Supply chain due diligence is obviously a big one, financial reporting, and greenwashing is another huge issue. So these are all the kinds of issues that we typically think of as ESG issues, but more, arise on a very regular basis in our industry. And in terms of in dealing with the risk, and this is where sort of the financial aspect, the cost comes in, the cost of doing business, where commercial risk is concerned, you have a very strong commercial incentive to respond to these risks properly. And we do that by developing new, cool, more sustainable products. We do that by adapting our business practices. And that's costly, but there's also a very big upside. That's where you can turn your risks into opportunities, by developing new products that appeal to the market, by demonstrating that you're a good corporate citizen. You do improve your market position. So you can, take a commercial risk, and if you play your cards right, you can actually, make lemonade. So, it is sort of a very fun process. Dealing with legal risks is more costly and it's more complicated, because you can't necessarily turn it into a commercial upside. You have to do what you have to do to participate in a particular regulatory environment. And what you're basically trying to do is identify where there could be disputes or regulatory action, or where you might be opening yourself up to a penalty, and do whatever you have to do to avoid that. And the first thing you do when you're doing that is kind of identify the risks. And Isabella showed us exactly, some of those kinds of risks. And we sit down and we map very carefully what are the risks in our organization. The next thing we do is assign responsibility for them, because it is a whole of business issue. So everybody has to be involved. And it's not the case that the legal department can solve all those problems. So we have to, for example, if we're talking about financial reporting, our finance department has to do that. If we're talking about packaging and recycling, our production and purchasing people have to do that. So we have very clear lines of responsibility. And what we do in the legal department is we direct and guide and answer questions, and we try to educate people, and we take care of our policies and our contracts to make sure that they're okay. But this is what is going on across business, I think, in every industry, because of this sustainability transformation. And it does take a lot of time and effort, and it does involve a lot of cost. But it ultimately, I think, is one of those issues that is kind of quite joyful to deal with in a way, because you realize you're doing something productive, you realize you're doing something positive, and you can, turn it into a commercial upside, which is then, better, good for your bottom line and good for your business.
Thank you so much, Amanda. That was tremendously insightful. And I think you're talking from a sort of privileged position, because you're working for a company who actually has as its goal, or, as a bottom line, that it wants to be compliant with ESG principles, because it wants to serve its customers and so on and so on. That might be different for some more established companies that are in the oil sector and so on. So they probably don't have this motives behind them, and for them it must be much more difficult to adhere to all these sort of ESG principles, because it really goes practically against their business model. So And I just was wondering, you know, from your in-house and legal perspective, is the threat of being subject to sort of strategic litigation, climate litigation, is this something that, you know, you take into consideration when making business decisions and saying, here we really have to adhere to that standards, or even to do some gold plating, because we definitely do not want to risk to be subject to a litigation in that area?
We absolutely do that, yeah, and we do that. I mean, we have obviously an indirect regulatory risk at the moment, and in certain areas a direct regulatory risk, and of course we're very, very careful about that. And we have, you know, the risk of disputes with our contractual partners who, you know, use tools such as risk shifting, which we're all familiar with as lawyers, and we then, you know, have to be aware of our risks and shift them appropriately as well. So we're always very aware of that. And I do think that, you know, it goes back to what we said at the beginning of this being such a huge issue for business and for society. There will be some industries who are, you know, affected in existentially, but not in a positive way. They may actually have to really transform their business model. You know, we tweak ours, we get to develop cool new products, etc. And other companies like fossil fuel companies will have to, you know, try to phase fossil fuels out and move into hydrogen or renewable energy or whatever. And you see them doing that, but it's all sort of on a scale, you know what I mean? We're all doing that, and some people have to do it more extensively than others, and certain businesses and certain industries, as is always the way, will, you know, possibly become obsolete, or, you know, really have to completely do a 180 in their identity. So I think it's, you know, from our perspective, it is a really exciting time, and it gels with our values. For companies for whom it does not, or for whom sustainability is a much more controversial issue or a threat. I mean, I believe, you know, they have to do exactly what we do, but on a much bigger scale, and be much more aggressive and much more creative about it. I think that's really there's no alternative. We're all facing this, and we all have to do it together, basically.
Yeah. Yeah. Isabella, would you like to comment on Amanda's insights?
I don't think I've got anything to add at the moment.
Okay. Viren, what about you?
Well, you know, the only observation I'll make from my experience working with, let's say, US companies that are dealing with operations in Europe is, to some extent, there's a concern for multinationals about sort of the patchwork application of laws and regulations in different jurisdictions. And a frequent question that I get is, you know, if the Norwegian Transparency Act or the French Vigilance Act requires me to do these particular things, but I don't have a corresponding obligation under the US or in my Asia operations, how do I present all of this in the sustainability annual report? Or, so, you know, do I harmonize across the board, or do I just limit exposure to the specific tasks that I'm required to do under each of these laws? And I think what we see generally is that for those companies that have sort of more global operations and are not limited to essentially operating in one domestic jurisdiction, a sort of ratcheting it up, that because you have, you know, these requirements in various European countries and the EU the reporting directive, that does actually impact the US subsidiary or the US parent company, or just the US company that does business with Europe, because they may have to be responding to those requests from their European counterparties, or they have to be thinking about it on a global scale. So that does add to a level of complexity here. Things are changing, as Amanda said, and we know more stuff is coming, but it also is coming from different places, and how to address that.
Yeah. Thank you so much. And I think it's a good way to leading over to your topic, because you will now wearing the US lens, and with the US lens and US perspective, reflect on the various EU ESG related directives, such as the Corporate Sustainability Due Diligence Directive that is not yet in force, and the Corporate Sustainability Reporting Directive that is already in force, including the Green Claims Directive and the Taxonomy Directive. I mean, how does that impact US companies? Do they care about it? And in addition to that, we have seen, especially in the US, a sort of ESG backlash movement that is very much tied also with the political clash between the Democratic and the Republican Party, and how does this all affect, US companies doing business, in particular in Europe or with a European angle?
Sure. Thank you, Alice. I mean, US companies, the US does have a reputation generally for lagging behind in ESG regulations and laws than, let's say, the European Union and the United Kingdom. There are some disclosure reporting laws here in the US, for example, for conflict minerals, which has been, pretty well accepted in the US. Some states like California have Transparency in Supply Chain Act and have to make certain disclosures on their website about human trafficking concerns there. Actually, to Amanda's question to Isabella in the very beginning on where we might see other ESG litigation in the vein of climate change, I do think that there are some initiatives in the human trafficking element. And actually many of the initial reporting requirements were focused on trafficking, right? The UK Anti-Modern Slavery Act, and as I mentioned, the California Supply Transparency Act. So I think that's another area in which we're going to see things where now Europe has sort of taken the lead in some ways with individual member states having passed these reporting laws, right? I just mentioned the UK Anti-Slavery Act, but also the French Duty of Vigilance, and then in Germany, the due diligence obligation, the Norwegian Transparency Act, and now the EU Sustainability Reporting Directive. And they largely focus on, getting your house in order, right? Making sure that you have the processes and governance structures in place to identify your ESG risks, and then to look at ways in which you are mitigating and remedying them, and then largely reporting on this. And there are certain fines, or if you're failing to live up to this. What we're seeing sort of as a progressive trend is these laws are not just applying to companies that maybe are incorporated or headquartered in that particular jurisdiction, but tend to be of a certain size. And size can be measured, in the sense of the number of employees, or size can be measured in terms of annual revenues. And therefore, for at least certain US companies of a particular size that have operations in, let's say, Europe, or are customers of companies that are in Europe, there's going to be much more a direct look that these laws, even if they are the EU law, might have a component that affects the US business or affects the parent company. So with regard to the EU Corporate Sustainability Reporting Directive, there are estimates right now that as this law goes into effect, and it's sort of rolled out for a number of years as to who must comply with it in 2024, 2025, 2026, 2027, and so on. But it's expected that at least as of now, down the line, 10,000 US companies will be impacted in some way because they are either publicly traded on the EU market, or they have EU revenue from the EU zone of more than 150 million euros, or they have a EU branch that has revenues of more than 40 million euros, or they have EU-based employees, etc. And so there's a wide number of multinational US companies that are going to be impacted by these laws. And what's interesting here is, there is a bit of a difference sometimes in what these laws require, right? In the EU Corporate Sustainability Reporting Directive, there's a sort of mandatory assurance requirement for all reported sustainability information that the company discloses. And I mentioned earlier on Isabella's remarks that, there's this draft SEC climate change disclosure rule that's pending here in the US. And that assurance standard from a third party is different from what is in the EU directive. And so there are going to be questions then from an audit and reporting requirement, what level of certification and assurance do we need? So basically the short answer is yes, US companies are looking at all of these things that are happening in jurisdictions like the EU or individual EU member states. But taking a step back to what's going on then in the United States itself, I mean, you have a little bit of an ideological battle that's going on in this country about ESG, and at a very high level, and I'm not meaning to stereotype or be reductive in the way I'm presenting it, but it really comes from what people say is a conservative Republican movement against ESG and a sort of Democrat or progressive liberal agenda in favor of sort of ESG initiatives. And so we're seeing how this sort of partisan debate plays out really at at both the state level, but also at the federal level. At the state level, for example, there have been a number of states, or I think nearly 20 states, have launched investigations into ESG investing practices of certain banks and their role in voluntary industry organizations that are tied to ESG initiatives, such as like the UN Net Zero Banking Alliance, to ask whether these companies, these banks, are fulfilling their fiduciary duties in terms of maximizing shareholder revenue and return, or are being quote unquote distracted or not fulfilling their fiduciary duties by focusing on non-pecuniary obligations. That's how they're sort of defining them, such as ESG concerns. And you have states, you know, that are actually adopting laws or regulations or making policy statements from, you know, levels like the state senators or the state attorney generals that sort of prohibit or discourage public entities from considering ESG initiatives when investing state resources. Now, this plays out primarily at the level of, for example, state pension funds or retirement funds, or what we call in the United States 401k retirement funds, because that's where there can be a regulation of at least, okay, put aside fully private funds or hedge funds, but if you are a public company or you are a public pension fund or retirement fund, that's really where we're seeing the active battleground of these ESG partisan debates. Now, I mentioned this is both at the state level, but also at the federal level. You know, in 2020, under the Trump administration, the Labor Department proposed a rule that would change ERISA, which is sort of the statutory law governing retirement accounts, among other things, pension funds, pension plans, 401ks. Basically, the proposal was to always put economic interests ahead of non-pecuniary goals being the code for ESG. And then in 2023 of this year, under the Biden administration, the US Department of Labor amended its regulation under ERISA to permit, but not require investment decision makers to consider ESG factors when selecting 401k investment options. Now, this wasn't a requirement that you have to affirmatively look at ESG factors, but it was that you are permitted to and are not foreclosed from doing so. Now, there's sort of an option here in sort of US rulemaking that allows for Congress to essentially stop an agency from issuing such a rule or regulation, right? Because this was coming out of the US Department of Labor, and there's a procedure whereby this can go, the stopping of it can happen unless the president vetoes the act of Congress, or you get a certain supermajority in Congress to continue with sort of preventing that regulation from going into effect. And President Biden exercised his veto in response to a congressional initiative to not allow the Department of Labor to consider ESG. So he exercised his veto, and his sort of view was, well, of course, it makes sense, economic sense, to include ESG considerations when considering a 401k and pension plans and retirement funds. But that is really what this debate is over. Does it make sense or not? So at the federal level, that's what is playing out. And, you know, if President Trump is likely the Republican candidate, there may be a return to focus on that being from the Republican side. And of course, President Biden has expressed his views now, and most recently in this Department of Labor issue. Now, the battle is also being fought out in other areas that's sort of interesting. We're seeing antitrust and ESG claims being contemplated here in the United States. Several US senators have sent law firms letters saying, you know, we want to be careful of institutionalized antitrust violations being done in the name of ESG. And here the concern is that proxy advisors who are advising shareholders of, you know, institutional investors on how to vote on initiatives are sort of colluding is the allegation. I mean, you know, but what others would say is collaborating on these sort of industry initiatives in the ESG space, and suggesting that that sort of collaboration and these voluntary industry associations are becoming forums for antitrust, anti-competitive behavior, sort of collusion. What was interesting is that the FTC Commissioner, Lina Khan, actually made a statement, I think it was in the Wall Street Journal, where she basically took the position that, you know, sustainability initiatives are not exempt from the coverage of antitrust laws in the US. And that in and of itself is not controversial. But I think what is getting more scrutiny is the sort of discussion by industry leaders and players as to whether or not to take ESG initiatives, whether that is somehow being cast in the vein of, you know, things like price fixing, bid rigging, boycotting, market allocation schemes, which are sort of the really antitrust claims, whether these live up to all of that. So we're seeing some of that in the ESG antitrust space. And then basically the SEC still is focused on ESG enforcement issues. The SEC established the Climate Change and ESG Task Force in 2021 that resulted in this proposed rule amendment in 2022 that's now being commented on. But, the SEC has gone after companies such as Vale, looking, relating to the collapse of the dam in Brazil and Vale's mining operations there, whether Vale had manipulated its safety audits or obtained fraudulent safety certificates or misstated to investors about the safety standards of the mines. The Federal Trade Commission is looking at its green guides to advise companies on whether what they're marketing, is about the environmental benefits could qualify as material misstatements to investors. There's also concern sometimes about greenwashing, which is false or misleading statements about the environmental benefits or performance of a product or operation. And shareholders are bringing lawsuits about that, and so are customers, in the US market. So it definitely is a very active space here in the US. I think one more area that's going to also get a lot of scrutiny, and maybe this goes to Amanda's point of where else, we're going to see litigation and the S perhaps of ESG, is diversity. There has been an initiative to promote diversity at board levels and in senior management, but there was a very polarizing decision that came out of the US Supreme Court in the last term regarding the constitutionality or the unconstitutionality of affirmative action by universities. And where that's playing out right now is certain groups are writing to law firms and private companies that have diversity fellowships, right, to encourage those from non-traditional backgrounds who are seeking opportunities to get fellowships to come do internships or get their first foot or in the door on the corporate ladder. And we're seeing now that in response to the Supreme Court case on affirmative action in universities, several law firms are now, and companies are revising those fellowships and scholarships to not focus on race-based scholarships, but to focus on a broader definition of diversity that does not turn on race, but may turn on socioeconomic disadvantage. And so, I think in the DEI space, again, you've got the same tension generally. It's a microcosmic example of the ESG partisan battle that's going on. But, pro-diversity initiatives that are become sort of commonplace and expected, and now a sort of backlash by a concern that these are too race-based and need to be revised in light of the US Supreme Court decision. So those are the things that are happening in the US in a nutshell.
Thank you so much, Viren. That was really brilliant and gave us a great overview. I have one question. I think I've heard in the past that also US corporations are sort of complaining that over-regulation or making it difficult for them to get permissions, in particular the larger oil and coal companies, and also the practice of sue and settle is putting them at an international disadvantage, and basically looking at the big picture of putting the US economy first. All these ESG initiatives should be cut down because eventually this will be to the detriment of the US consumers. Is this also something you see and you can confirm?
Well, we definitely hear that argument, and it's not just a US-based argument. It also applies in the European Union, and sort of this idea that the more regulations that we have in favor of things like ESG and the E then, for example, for energy companies in terms of the environmental impact studies that they have to do and the sort of permitting process and the difficulties of getting through that might make it harder for certain companies to operate in jurisdictions like the US or US companies operating elsewhere in the world, but subject to US reporting and other regulatory requirements are more onerous than, and the classic example is Chinese companies, for example, that are their competitors. So you definitely hear that argument. What's been interesting to me on the environmental front in this space is this sort of the energy transition, right? And moving away from fossil fuels to renewable energy. And you are seeing initiatives in the European Union, but also in the United States here with the Inflation Reduction Act that are meant to sort of incentivize domestic players to source within, let's say, the United States and to build within the supply chain from, US, as much US based as you can to qualify then for the maximum tax and equity benefits that you can get. And part of this is trying to rejigger things to try to, strengthen domestic enterprises and sectors, but also to make sure that there isn't too much influence on China, for example. And this really is playing out in, for example, like solar energy, where a lot of the photovoltaic cells are coming from, are manufactured in China and then feed into whatever's being used in the US here with solar plants or other parts of the world. And a conscious reliance here by the Inflation Reduction Act and comparable measures that have been implemented in the EU to redirect and divert that. So yes, you are right, Alisa, there is this concern about, more laws and regulations make us less competitive, but then equally other legislation that has economic incentives built in to strengthen domestic businesses in this regard.
Thank you. Amanda, a question to you as well. I mean, overregulation, is that a threat, of being less competitive? And also what Viren mentioned, sourcing locally, is this something that is also in the head of businesses who are based in Europe?
Yeah, I mean, obviously, we have the same issue facing different regulation in different jurisdictions, and supply chain issues are a classic example of that. We have the Modern Slavery Act in the UK and in Australia, and we have the Loi de Vigilance, and we have the German legislation. And to a certain extent, obviously you have to understand what your legal obligations are in every jurisdiction that you operate in. But I think when you're talking about sort of policies and so on, the net impact of that is that you're forced to follow the highest standard. And that's not necessarily a bad thing. So, I mean, if you want to be safe, you take the high watermark and you do, everything that you're supposed to do. And hopefully you've covered off all of your bases with that. And to a certain extent, I think regulation can make your life in business more difficult, but well thought out regulation is actually quite helpful, and regulation that is consistent and things like the EU directive on supply chain due diligence will actually help, because at the moment we do have a situation where we're comparing 10 different laws, and that is more difficult. So I think in those areas, specific areas, it has to be well thought out, it has to be targeted. It is useful to have regulation. It is useful to have those signposts to crystallize those risks for you, as I mentioned, to define them and let you know what's going to happen if you don't do it. And it does make everybody, there's a risk, that small businesses say, well, this is not something that I have to worry about. That medium-sized businesses say, this is not something that I have to worry about. And then it just becomes something that's dealt with by the very big businesses. And that's not going to work either. I mean, if you really do want a sustainability transformation, we all have to do our part. So I do think that the regulation helps with that. And I think that the reality of it is, because it is such a big issue, we all have to do it. It does probably have some impact on competition, but if the regulation is well thought out and well planned, it should have, sort of an impact commensurate with your impact on the environment. And so far, I think, I do think that the regulators are doing their best. And I think there does need to be some dialogue with people who are actually implementing these regulations to really get it right. But it's in all of our interests that we do that. And I'm positive that that's the way it will play out.
Yeah, thank you. Isabella, just quick question to you, and also asking you to comment a bit on Viren's presentation. How do you see the ESG backlash movement in Europe and the UK, also according to the studies? Is this something that is equally worrying also in that part of the world?
I mean, from what I've seen, the backlash is nowhere near what it is in the US, certainly from that same sort of level and perspective. Yeah, I mean, I don't think it's anything like that at all. I don't know. I'm sure the others are more qualified to comment on that. I did want to pick up on something that Viren mentioned about fiduciary duties, because we talk a lot about corporate liabilities, and I wondered what you thought about the perspective of company directors being held personally liable for ESG, for the way that they handled their company's ESG requirements.
So it definitely is a complicated area, and something that's of concern to directors of publicly traded companies in particular. I don't work on this directly myself, but what my colleagues who do a lot of what we call white collar crime work, when working with directors and officers, of companies, essentially is to make sure that you have good governance structures that are in place, that the process can be used to defend them for whatever alleged ESG violation or reputational issue might come down the line. And that means that, that there is frequent reporting to the board about ESG initiatives on the sort of major pillars of business and human rights of, prevention, protecting, remedying on the human rights front, but more broadly than for ESG, that those presentations to the board are sort of vetted from, the perspective of they could be disclosed in litigation against directors and officers or the companies, that there is a board recognition that's captured in the board meeting minutes about the response of the board on the issues of ESG that are being presented to them. And then also a good scrutiny of your indemnification and insurance agreements, if you are a director, to make sure they expressly account for liability for ESG risks. So I guess the two answers I would say are process matters if you're a director, in terms of making sure you have access to the ESG information that is being reported to you, and that is acknowledged and captured somewhere, and the board responses on these issues are captured and codified somewhere in the minutes. And then separately, that companies, when they're looking at the DNO, Director and Officer Insurance, are expressly providing for ESG as well. That's what we see in the US, and I'm pretty sure in Europe it's probably not dissimilar.
Amanda, would you like to share a little how this is in your company? I mean, directors' liability, is that a big issue, or I guess to a certain extent, yes, as everywhere.
I mean, it is obviously, and our managers obviously, take responsibility for the company, and in a large part of our operations in Austria, and the obligations for directors are, quite stringent, obviously. And I think it just sort of rolls into their general obligation to manage the company properly. And then it really will depend on what the individual laws say in terms of how far the directors have to go. But certainly it's an issue that's taken very seriously. I think it's taken seriously irrespective of any specific director's duty, because it is such a big issue and such a commercial issue, commercial risk and a legal risk for us. But those, sort of specifying exactly what the obligation is and exactly what the penalty, it does clarify and crystallize the issue and make, I think it adds teeth to the regulation, and just, focuses the mind really on what really has to be done. So yes, but I mean, I think it really obviously depends on the size of your company, the industry you're in then, and also things like whether you're listed or not listed, etc. But generally speaking, sustainability is an issue that's front of mind for all of our managers, and it sort of rolls into their general obligation to manage the company in accordance with the law.
Thank you. I just saw that we have a question in the chat that I would like to read out loud to the panel, which comes from Lucas, and it reads: when a large oil company is ordered by courts to reduce its CO2 emissions, the easiest way of doing so can be to simply sell part of its assets in various jurisdictions to companies not facing such court or legal constraints. How do we guarantee that emissions will indeed be reduced as intended by these claims and decisions, instead of only seeing the changing hands of CO2 intensive assets? That's a very good question. Who would like to go first? And I think we all know what case that actually relates to.
What I can say here is that there's been a real scrutiny of the use of carbon trading to sort of offset your carbon footprint, and whether that's actually achieving the sort of climate objectives of a company in a proper or improper manner. And there's sort of reputational issues with that. Some jurisdictions in the US, such as California, are passing certain green guide marketing laws that sort of require more disclosure by companies as to how they're achieving their net zero or carbon offset, or greenhouse gas emission reduction targets. So for example, if you're planting trees to reduce carbon to offset your footprint, but you're not doing anything within the business to lower your greenhouse gas emissions or to use cleaner sources of energy, then that could qualify as greenwashing, and fall afoul of some of these marketing laws and allow for then consumer lawsuits to be filed. I also will say, right now, and there are all these national proceedings that are taking place that Isabella shared and were captured on the slide, but there are also are these various international law proceedings that are taking place before forums like the International Tribunal for the Law of the Sea, the Inter-American Court on Human Rights, and also the International Court of Justice. And these three matters are all advisory opinions in which, certain member states or the General Assembly, in the case of the ICJ, have requested these courts to issue advisory opinions on essentially the obligations of states under international law on regarding the climate emergency. And where I think this question is relevant is, especially in the Inter-American Court request from Chile and Colombia, one of the specific questions to that court is, what are the obligations that states must impose on private companies that are doing business in their jurisdictions regarding the climate emergency, and go to these kinds of questions of actual reduction in greenhouse gas emissions and what that form can look like. There's also a big concern with some of these, deforestation initiatives, clean energy, on the human rights impacts that they have. And are you just buying and selling on the market, but not actually changing your business practices to account for ESG or climate change risks? So I think it's a good question. I think there's going to be more scrutiny. You don't just get away with saying you're reducing your emissions and carbon footprint by doing this. There's going to be a reputational issue, and I think you might have legal issues in the form of like this marketing greenwashing laws.
Yeah, that's just what I wanted to say. And I think, Isabella, you mentioned it in your introduction that, sometimes these lawsuits, they make headlines, but do they really cut down the greenhouse gases? And actually, if the outcome is exactly that businesses are divested to investors who are really not subject to any kind of reporting directives, then actually the effect is worse than it had been before. Maybe as a very last issue, this evolving area of, I think we even call it climate washing cases. Isabella, can you maybe as a closing remark, and then followed by the others, tell us, what perspective do you see, or what role do you see for these climate washing cases? Will they play a more important role in the future?
By climate washing, do you mean the sort of the climate section of
Yes.
greenwashing?
Yeah, exactly. Well, it has been said that greenwashing is probably not, it's too narrow, because now that corporations are introducing certain measures and so on, they want to also advertise it, and and that could lead to all sorts of different claims.
Yeah, I mean, that is certainly already happening. Sometimes these definitions are a little bit fuzzy, what you count. The greenwashing case, what falls in different categories. And a lot of those greenwashing cases certainly do cover climate-related issues. So there have been quite a few, for example, against the airline industry for making claims about the sustainability of their products, of their transport, when really they've made very, very minor changes, as Viren was talking about as well, in terms of offsetting their emissions and misleading customers as to what that really means. So I think there's going to be more and more of these brought by individual organizations and by regulators. The interesting flip side to this is a phenomenon that's been dubbed sort of climate hushing, where companies are actually quite reticent to talk about what they're doing, even if they are doing things that are fairly progressive in an environmental sphere, because of the concern that will then be picked up on and criticized or even subject to litigation. So there is this sort of delicate balance between wanting companies to be ambitious, and certainly environmentalists have in a way backed them into a corner by doing this, by saying we want you to be very explicit about what you're doing because we want to hold you to account, but there is occasionally a fear as well of doing that and what the implications might be, which is again I think why the disclosure rules are so important in forcing companies to be really more open about what they're doing.
Yeah, thank you very much. And Viren, there was a comparison to the tobacco cases in the US, where the tobacco companies were held accountable because they were downplaying the potential risks that tobacco had on consumers. Do you think that could be a new set of cases in concerning climate related issues, where companies are downplaying the effects that they might have on the climate, and that will then be a reason to sue them and hold them accountable?
So that's already happening. I'm forgetting right now the case, but I think it's California has brought a lawsuit against, I believe, 6 energy companies, and it at least includes Chevron and ConocoPhillips in the US, and I'm forgetting the names of the other defendants. But it relates to essentially this issue that for at least, I think it's like 5 decades, a lot of these major US oil companies and maybe international oil companies have known about internally the effects of their business on greenhouse gas emissions that contributes to the climate crisis, and did not disclose that or alter their business practice. And this has been alleged previously by individual plaintiffs in different forums, and most of the time a lot of these cases have been lost on things like standing or forum non-convenience, or the right, essentially the right forum to bring these claims, or who has the standing to advocate them. I believe, if I'm not getting it wrong, because I'm going off what I read in the press a few weeks ago, but I do think it is California, and this has got quite a lot of attention because it's a state that's been pursuing this. There have been investigations done by the New York Attorney General as well, I think, into ExxonMobil, and Exxon might actually be named as well as one of the defendants in this lawsuit, about what its scientists and management knew about greenhouse gas emissions. So you're right, Alice, at least in the US, this is happening right now. And it's not just, current data, it's going back to the 70s, I believe, actually. It's sort of 50 years of knowledge of this issue.
So Amanda, that means also the marketing department has to be scrutinized and has to be very careful about, what you say today might have a big impact on the future, on how you present the company. Of course, you always want to present your own company in a good light, of also making known to the public what initiatives you're doing in order to improve the environment and so on. But I think one has to be mindful and careful to stick to the truth and not overdoing it. Would you agree to that?
I mean, I think that's absolutely true. And I think, again, here there is a role for, clear regulation on what is allowed and what is not allowed. And part of the problem, I think, is, leaving aside those large companies that may be named in lawsuits who are dealing in the fossil fuel industries, there's a lot of people out there who are acting with the best intentions. And it's a definitional problem. We don't know what we're talking about half of the time because nobody, has put a clear definition on what it is we're talking about. And people are sometimes talking about different things. So that is a role for regulators. That is a role for the legal department as well, to make sure that we are telling the truth and we're not getting carried away. And we're also being transparent so that we can, have honest conversations with our stakeholders about what it is that we're doing. And I do agree that that's going to be a big area to watch in terms of risks for businesses going forward.
I think that was a perfect ending to a perfect webinar. I really would like to thank all 3 of you for your excellent presentations and interventions. We have made a recording and we will put this online and share it with the greater audience. And let me really thank you so much on your excellent presentations. And a note that the next webinars will be held on 15th November and on 13th December on climate change and investment arbitration and climate change and commercial arbitration. So please stay tuned for that. And with this, I conclude the webinar and thank you again so much. It was a pleasure.